The legal procedure of inquest. Today I am going to talk. It is defined as an inquiry into the cause of death which is clearly not due to natural causes. Inquest means in, positos means to see. There are many types of the inquest like coroner's inquest, police inquest, magistrate's inquest and medical examining system of. Earlier in India, there used to be a system of inquest, what is known as coroner system of inquest, which is not existing in India. It is already abolished. And the coroner used to be a special officer appointed under Coroner's Act 1871. He used to come from the law background, like usually an advocate or attorney or a pleader, first class magistrate with 5 years experience, or he would have been a metropolitan magistrate who is transferred, or a maybe medical person. He was called as a coroner because he was a keeper of the police of the crown. Coroner's office used to be an ancient office under English common law. He had a wide variety of the functions like inquiry into the shipwrecks, fires, unnatural deaths, and even catching the royal fishes. So later point in time, many of his functions of the coroner were shed, and his functions were only restricted to the inquiry into the unnatural deaths. The powers of the coroner. He is empowered to inquire into the causes of unnatural or suspicious deaths. He got a power to commit a suspected person or accused to stand trial before a magistrate. He can view a body to decide whether or not autopsy is required. He can order exhumation of the body for identification or any other medical legal purpose. He is authorized to order and qualified registered medical practitioner to conduct a post-mortem examination and summon him as an expert witness to the court. He can grant conduct money. He is empowered to appoint an in-charge coroner during his absence. Coroner's court used to be only court of inquiry into the unnatural causes of death. Presence of suspect or accused was not necessary. It has no power to impose fines or sentences. Circumstances where the coroner's inquest was held was sudden death, murder, infanticide, suicide, death by accident or poison, death due to mishap by machinery, death occurring during operation or under anesthesia, deaths occurring in prison, police custody, asylum, hostel schools, etc. The police inquest. Here, the police officer not below the rank of head constable will hold the inquiry into the unnatural deaths, and he is called as a IO or investigating officer, and he prepares a report, that is what is known as police inquest report. How it is exactly prepared, we'll see in the next slide. IO on rushing to the spot with the help of the local people who are popularly known as panchas or pancha witnesses or panchayatdars, he prepares a report as judged by him and the panchas, and both IO as well as local witnesses will sign the report, that is what is known as Panchanama or inquest report. If no foul play is suspected, he can hand over the body to the relatives for disposal. In case he suspects or doubts of cause of death, he can request for medico legal autopsy. Trial of the case will start with the production of the entire case records to the magistrate. Magistrate's inquest, which is contained in section 176 CRPC, it is based on the assumption that it is not always safe to or advisable to rely upon the police inquest. This normally he will hold an inquest in cases like death of a convict in a jail, death of a person in police custody or during interrogation, death as a result of police firing, exhumation cases, high sensitive cases like dowry deaths, etc. The reason for magistrate's inquest is no person is deprived of his liberty and his rights as a citizen. No person is allowed to die or deprived of his right due to neglect or brutality by the people in whose charge he or she is. Doubt about the identity, cause of death, the manner of death of a person who is already buried. In these circumstances also, the magistrate inquest is entered. Medical examiner system of inquest. This is prevalent in the many states of the USA. Here, the medical man, that is, who is qualified in the medical field, like forensic pathologist, who will conduct the inquest as well as a post-mortem examination. So, hence, it is considered as the most superior to all other types of inquest. Courts of India. Supreme Court is the highest judicial tribunal which is located in New Delhi, that is the nation's capital. High courts, normally they are the higher judicial tribunals in the state, and they are usually located in the state capital. And the subordinate courts are session courts. Then subordinate to the session courts are magistrate courts. They may be presided by the chief judicial magistrate of first class, judicial magistrate of second class, like this. Supreme Court is located in the nation capital, and the Supreme Court is presided by the Chief Justice of India, and he is assisted by the other Supreme Court judges. This is a hierarchy of Indian judiciary system. Sentences authorized by the law under 53 IPC can be death sentence, can be a life imprisonment, or imprisonment can be rigorous, simple, solitary confinement, can be a forfeiture of the property which is now abolished, can be fine, go to any amount, or sending a convicted person for training and rehabilitation if he is a young offender. Supreme Court can pass any sentence, usually considers appeals from the lower courts. High Court can try any offence and pass any sentence. It also usually considers appeal from the lower courts. Session courts can try only offences which are committed to it by the magistrate courts. Can pass any sentence. Only thing is death sentence has to be confirmed from the High Court. Magistrate courts presided by Chief Judicial Magistrate and Chief Metropolitan Magistrate, which are located in taluk and subdivisions of the districts, can pass a sentence of up to imprisonment 7 years and fine without limit. First class judicial magistrate can pass a sentence imprisonment up to 3 years and fine up to 5,000. Second class judicial magistrate can imprison a person for 1 year and fine up to 1,000 rupees. The court proceedings. Usually it can be discussed under these headings. We will discuss about the summons or subpoena, oath of affirmation, recording of the evidence or proof, decision of the judge or court, the execution of the court orders. Summons. It is a document compelling the attendance of the witness on a particular date and time and place to give the evidence. It is a invitation or call from the court. It is issued by the court in writing and it is bearing the sign and seal of the presiding officer. It is served by a police officer or sometimes maybe from the government officer if it is for the subordinate officer or maybe any other government employee. A summons must be implicitly obeyed unless there are valid and urgent reasons. If the summoned witness fails to attend to the court, he is punished for the guilt of contempt of court. Priority of the attendance to the courts I will discuss in the next slide. The conduct money. This is the amount paid to the witness to the attend to the courts in civil cases. This is to meet his expenses for traveling and that day's expenses. If a witness has got a summons to attend to the court on the same day, how to give the preference? The criminal courts have precedence over civil courts, higher courts get preference over lower courts, and the court which served the summons first receives preference. Failure to obey summons, in case of civil cases, he may have to pay the damages, and in case of criminal cases, the witness might be imprisoned, or the court may issue the warrant of arrest and compulsory attendance. The conduct money, I have already discussed. In civil cases, it is paid to cover the expenses of witness to attend to the court at the time of serving the summons. It is the amount paid by the party that has called the witness. In criminal cases, no conduct money, but court has made a provision to pay reasonable expenses of a witness. A witness. A witness is a person who gives statement or testimony under oath or solemn affirmation in the court of law. He can be a common witness, he can be an expert or skilled witness. Expert witness are the people who have got a special knowledge in some particular field, like he may be chemical examiner, fingerprint expert, ballistic expert, forensic expert, doctors, etc. Evidence. Evidence means any statement in relation to the matter or fact under inquiry, or it can be a document or something for the inspection of the court. It can be oral evidence, it can be documentary evidence. The oral evidence, if a person who says he has saw, heard, or perceived it, in other words, actual witness. A documentary evidence is any document produced for the inspection of the court in relation to the matter of fact under inquiry. Medical evidence. He can be both. He can be he can be oral evidence he can give, or the documents of the doctors can also be given as a evidence. The medical certificates like sickness certificate, medical fitness certificate, fitness for employment, vaccination certificate, death certificates are usually issued by the doctor on the requisition of the patient or a person. Here, a law enforcing agency will not request for these certificates. Medical legal reports, injury, wound certificate, age certificate, potency certificate, drunkenness certificate, examination of the victim or accused of the rape or sodomy, post-mortem reports. These are the reports submitted on the requisition of the law enforcing agency. The oral evidence statement is given by a person himself. It must be direct and which refers to the fact under inquiry. The person who has seen, heard, or perceived by his senses, he will be the actual witness. The oral evidence is considered superior to the documentary evidence. Hearsay evidence. Evidence of a person who has no personal knowledge of the facts but just repeats what he or she heard others say. Circumstantial evidence. It is an evidence when something found which gives clues about the offense. On receiving the summons, once the witness attends to the court, he will be administered the oath. It is the declaration required by the law to be made before the court by the witness. He swears in the name of the God that he will tell the truth, the whole truth, and nothing but the truth. If the witness has a religious scruples against swearing, he will be permitted to make a solemn affirmation. Once a witness thus sworn, if he does not speak the truth, he is liable to be prosecuted for guilt of the crime called forgery, that is, willful utterance of falsehood, which is dealt under section 193 IPC. The recording of the evidence or pleading is takes place under these headings, like first, examination in chief, cross examination, re examination, questions by the judge. The examination in chief. Here, the examination is done by the counsel side which has summoned him. The objective of the examination in chief is to present all the relevant facts of the case before the court. If the witness is expert, he may be asked to elicit his inference or interpretation from the facts. No leading questions are allowed here. A leading question is the one which suggests the own answer in the question itself. Hostile witness is that witness who gives evidence in the court of law under oath against the interest of the party who cites him as a witness. Allowed here, the cross examination need not be confined to the statements. It may be the questions may be thrown or asked about qualification, experiences, professional knowledge, character. No time limit for re-examination. After cross-examination, the witness can be examined by the counsel who had called him to remove any doubts that may have arisen during cross-examination. Leading questions are not allowed again. The court questions. Presiding officer or the judge can ask questions any time in the trial. He can call a witness again for his evidence if needed by the court related to the same matter. Non-cognizable offences for which the police officer without the warrant cannot arrest the accused, who is accused in bribery, defamation, forgery, causing simple hurt, buying or selling person for slavery. Offences like waging war against government, counterfeiting Indian currency, adulteration of food, destroying, damaging, defiling place of worship, theft, robbery, murder, kidnapping, rape, attempting suicide, causing grievous hurt, dowry death, revoting all constitute what is known as cognizable offence. That is, any offence for which the police officer may arrest the accused without a warrant. The doctor in the witness box. It is a common sense he should dress up decently and he should behave decently. In the witness box, he should stand straight and he should address the judge, Your Honor or Sir, and attending the court punctually with all documents required to the court. Study the documents before attending to the court. Avoid any unnecessary talks in the premises of the court. Evidence should be given with a clear and loud voice. Statement should be simple words and avoid technical terms. He may demonstrate his evidence by documentary support like photographs and diagrams or videographs. Thank you.